sure why I thought that. Maybe I thought she only worked during the day. But I happened to notice that she was up at the bar area, which is where you had to put.
Right from the start, you're dropped into a small-town courtroom where the drama is anything but small. Real people are on the line, facing real consequences. And trust me, this case has more unexpected turns than a soap opera, only this time, the drama comes with subpoenas. Let's dive in.
Order in. I did not go up there, and I refrained from going up that way. And so I don't know if she saw me or not, but we for sure didn't have any conversation. Would that be accurate?
That'd be accurate.
Okay. So I just wanted to disclose that for the record, just because I was there for the fish fry.
It's a small town.
Thank you.
It is. Lots of fish fries in the small town. That just happened to be the one that we picked to go to. Okay. So I understand that there has been a resolution.
That's correct, Your Honor. If you'd like, I can read it into the record.
Yes, please.
Okay, so what the parties had a chance to meet for this morning, and what we decided is that Ms. Collins will vacate the premises no later than March 31st, 2025. Currently, there is $7,000 being held in escrow, and the escrow shall be released as follows. $5,500 of the funds being held in escrow shall be released to the plaintiff, and the remaining $1,500 shall be released to the defendant. We are also agreed that Ms. Collins will pay the March utilities directly to the utility companies on time, and we have provided her with a copy of those invoices. The bills.
Okay, hold on a second. The judge just casually mentions that they ran into each other at a local fish fry. You can't make this stuff up. Only in a small-town courtroom would fried cod and legal disclosure end up in the same sentence.
As they stand are the Wyandotte electric internet bill, which is due March 18, 2025, in the amount of $154.55, and the DTE bill, which is due March 20, 2025, in the amount of $156.78. It's going to be further held that the plaintiff is going to remain in possession of the security deposit until such time that Ms. Collins completely vacates the premises, and there's a walkthrough to ensure that there's no money owing under the lease agreement for damages or the like. And that should the defendant fail to pay the utilities and leave them for Mr. Branson to pay, any monies owed on the utilities for the March payments will be deducted from the security deposit prior to the release of the remaining funds to Ms. Collins. And that is the sum and substance of what we agreed to this morning, Your Honor.
Okay. And Mr. Kvalla?
We're in agreement.
Okay. So let me just clarify a few things. One, that security deposit is in the amount of $2,000, correct? Or is it $1,500 or $1,750?
$2,000.
$2,000. Okay. And everyone's in agreement with that?
Yes.
Okay.
Here's where the legal insight kicks in, and it's crucial. Specific bills, due dates, and exact dollar amounts are being written into a formal court order. If those payments fall through, the security deposit isn't just money anymore. It becomes a legal chess piece. In situations like this, precision isn't optional. It's everything.
So then this agreement represents resolution of all of the issues.
That's correct.
The June 2024 rent issue, any other utilities issue, and any other issues that have been raised. And so that would resolve all of the pending matters as it relates to this claim.
That's correct, Your Honor. It's our intent that this be a global resolution of all remaining outstanding matters on this case.
Okay. Would that be accurate, counsel?
That's accurate.
Okay. So that needs to be reflected in the order as well. And I understand that you have a computer or something because you typed this all up and emailed it to us, which is fantastic. So I'd like for you to specify the amount of the security deposit, just so that there isn't any question. I'd like for this to be as specific as possible. Also, in this matter having come before the court. Okay, so this matter having come before this honorable court, comma, upon stipulation of the parties, comma, and the court being otherwise fully advised in the premises. Then it says $7,000 is there, so it should probably indicate.
Your Honor, that's a typo, and we sent you an additional copy since you've taken the bench that does not have that $7,000.
Boom. This is what's known as a global resolution. Think of it as a legal full stop. Both sides agree this settles everything. No do-overs, no surprise lawsuits popping up down the road. Courts love closure, and honestly, so do most exhausted landlords and tenants.
Dollars randomly placed in that sentence.
Okay, so I would like it is further ordered, before you start talking about the 5,500, it is further ordered that the $7,000 currently held in escrow, the court escrow, shall be dispersed as follows. As follows. And then continue with how you have it spelled out with who's getting that, those funds. And then if we can also have both clients' signatures on there as well. So you don't have to have those electronic signatures, you can just put a space for them to sign with the line, and then when it's printed up, they can physically sign.
Can that be printed up here so that's just...
Absolutely, yes.
The only other thing that I forgot to...
Heads up, this is a classic judge move. She's making sure the court order is crystal clear. No vague wording, no wiggle room for loopholes. The difference between held in escrow and disbursed as follows might seem small, but if phrased wrong, it could spark an entirely new legal battle.
Your Honor, is that we need a forwarding address, or we can send it to Ms. Tekola and the alternate, however she wants, for the earnest money for the deposit.
Okay. Mr. Clava, how would you like that to be handled? Do you want it to be sent to your office? Or do you want it to be sent to the forwarding address for your client?
You may send it to my office.
Okay, and in fact, we would need that information as well because we're the one the court's going to be dispersing those funds appropriately.
The 1,500 funds. Do you want to pick it up here?
This is a forwarding address for the disbursement of the amount in escrow, correct? Or are we talking about the security deposit or both?
Well, both. So we'll need it for both.
Okay.
So the court will need to know where we're going to be sending it. The $1,500. You can't just go right to the window today and get that money. We have to process it through and then we issue a check. We send a check.
When would how long does that take and when would I be able to get that?
Well, I don't know the answer to that. I will find out for you when I go grab the order. I will find out for you.
Yeah, because if I could get that while I'm still, before the end of March, then that would just be at the address I'm at right now.
I'm pretty sure it'd be before the end of March, but let me confirm that so I'm not giving you wrong information.
Because that would be just where I'm at right now, my address, my present address.
Okay.
Yeah.
Okay. And then for the security deposit, the balance of the security deposit, that would be going to Mr. Clava's office. Okay. Any other issues that were forgotten about?
You want that to be reflected in the order, Your Honor, or since it's on the record, we're good?
It should be in the order.
This is why she's so good, Judge. We bring her with us.
So while I'm waiting for that to come through, well, before you send that, let me just clarify a couple things. So there was an inspection done, and there are, because the court's been CC'd on all the email, well, at least on some of the emails that have gone back and forth between counsel. There was an email that was sent out regarding accessing the property to have certain items repaired that are required to be repaired. So is the intention to now delay that until Ms. Collins vacates the property March 31st?
Yes, Your Honor.
That's the best scenario for all. Okay. So let's put that in there as well, that Mr. Branson is deferring commencement of items needing to be corrected per the inspection until after March 31st, when Ms. Collins vacates the property.
Your Honor, my client is requesting that she may be able to sit. She's feeling faint.
Oh, that's fine. You can all have a seat, that's fine.
Is there anything else, Your Honor, that you'd like us to add to the order this time?
I believe that covers all of it. Let me just confirm something here.
Judge, I just want to add for the record that the city conducted an whole test of the area in the basement and it came out negative. I was just placing it on the record.
Okay, thank you.
My client is disputing this. I'm not sure. Just trying to close out the case here. But since we're on the record.
Okay, Mr. Gagger, do you have something that confirms that result from the city?
He was just told, my client was told, but you know what, Judge?
I don't think that, I mean,
It's not, none of this is relevant, it's just, I was just placing it on the record, but
Okay.
she corrected her record, so none of this is really relevant.
Okay, so the issues that were still outstanding were the June 2024 rent, security deposit, escrow money, utilities, and the February 26th inspection. That all appears to be included in this stipulated order, correct?
Correct.
Yes, Your Honor.
I think there needs to be a title other than stipulated order.
The final order?
We could say like maybe order resolving.
It could say consent order, consent order resolving.
All claims.
You wanted to identify your last order that just came out, I think on March 11th, that identified the specific issues that were supposed to be before this Thursday.
Yes. I don't believe you have to include the inspection portion because that's already concluded, so I don't think that that needs to be included.
What
Here.
if
But
we
if you want to reference you can just indicate rent, security deposit, escrow money, utilities. Would that be sufficient, counsel?
Yes.
Okay.
You want us to say, so right now we have it as consent order resolving rent, utility, security deposit, and escrow. Do you want us to say as identified in this court's order of March 11th?
No, that's okay, because those were the outstanding issues that we
Okay.
needed to resolve, so that doesn't have to, the date of the order doesn't have to be reflected. So one question, I just want to make sure that we're just tying up all loose ends and not intending to create any other issues. However, regarding the utilities, where it says it is further ordered, should defendant fail to pay the utilities, that amount should be deducted from the security deposit. Is there a late fee in the event utilities are not paid timely?
That would be to the city, not to me, so I don't know.
I understand that, but if you end up paying the utilities, if they're not paid,
We'll waive those, you know.
Yeah, no, I understand, yeah, no, ma'am, no.
okay. All right, so let's indicate, let's pause on that for a moment.